Really excited to wrap up this wonderful series that we've had with Keith. And my name is Jason Ingber. We're going to hear from the trial legend, the man, the myth, the legend, Keith, on some more amazing wisdom topics that you can learn on how to build your practice as well as take for you in the rest of your life. Keith, what are we going to talk about today? And then let's jump right into it.
All right, this will be the last in a series that we've been doing on this, what I call the wisdom of the wise, this surefire problem-solving process. And I'm going to apply it to one more example. I could do this for a week, but we'll do one more example of where it fits in. Again, we're going to use that classic car crash case where someone's got a herniated disc or that type of injury. So here's a classic one. All lawyers that do injury work have heard this one. And it is not a lot of visible property damage. And it has been the bane of our existence in the past until we figured out that it was another wannabe problem that, honest to goodness, is not a problem. So what is not a lot of visible property damage? Self-explanatory, but to any folks that are listening that aren't lawyers and may say, I think I know, I'll tell you exactly what it means. It means a lot of times for example, a rear end crash, there will not be the car won't be total. It won't be a mangled mess of metal. And sometimes it's, a dent that's not a big dent or a scratch. And so what's the defense do with that? Well, they say it wouldn't hurt a flea. And what do people generally react to that if they haven't been in the experience? Yeah, that doesn't look like it would cause any serious injury. But it can, and it will, and it does. So I've spent a lot of time, because a lot of cases have that involved, applying the wisdom of the wise to teach myself why it's not a problem, so I can then teach the other lawyers and ultimately jurors. So I want to get into that. But I want to start, before we do that, with one little background piece. I have lawyers say to me, yeah, but how come all my cases are like that? Why don't I have one or two and the car is really total, but most of them aren't. And I know that it's a cry for help, like, gosh, what did I do in another life that I'm cursed to have a caseload like this? And I say to them, I want you to think about it. When you've driven down the highway and you see a mangled mess on the side of the road, what do you say? Oh my God, someone's probably died. I hope there were no children in the car. I hope it wasn't a mother. You know why we say that? Because someone probably died. So when you have a herniated disc case, not a mangled mess total car case, it's the nature of the beast. It doesn't mean it won't hurt people. It just means it's a different kind of hurt. And you typically, in a total car, don't have a herniated disc. You got someone who's got a wrongful death case. So if you
is that something that you mention in negotiations with opposing counsel or with the jury, or is that just an internal mental check that you'll tell your younger
I don't usually bring that up with the jury, but that's a great question, because I'm not sure why not. I'm going to think about it. I might. I'd say anyone listening, think about if it fits, because it may be a piece that would add to what I already do that I tell lawyers behind the scene, but I'm not sure it's not a smart thing to say to them. And certainly you can say it to an adjuster. You can say, let me tell you, let me tell you what I'm going to tell the jury, so you can process it and decide, how much weight you're going to put on the fact there's not a lot of visible property damage. But anyhow, so my point is, don't feel like you're cursed. You know what you have? You got a herniated disc caseload. Your caseload's herniated disc. That's what they look like. That's what they are by nature. It doesn't make them bad cases. It doesn't make them discount cases. But guess who wants you to think that? Insurance adjusters and insurance companies and defense lawyers. Why? Because they got a built-in discount on almost all the herniated disc case. If you buy into that means I'm scared to go to trial. I'm going to take a big cut on the full value. They get a built-in automatic cut in the big value in almost every case, because almost all of them look like that. Don't let them get away with that. Don't let them do that. So, not because we found out a really cute way to get around the truth, because we found out the truth. So let me share how we got to the truth. And I'm going to apply that same model to this. Fixed fact. There isn't a lot of visible property damage. Wrong conclusion the defense is after. Wouldn't hurt a flea. Right conclusion that we're after. It did hurt the flea. And it will hurt the flea. Now, how do we get to the right answer? We focus hard on the circumstances, asking ourselves, why are we still right in spite of fill in the fact? And here the fact is there's not a lot of visible property damage. So how do we deal with that? We stare at it, we think about it, and here's the answer that came to me I want to share with you. First of all, I got thinking. When I was a kid, I played football. Pretty good. And people ran into me all the damn time. And I did get hurt some, but I'm not like walking away with a herniated disc. So someone hit me in the back. I was getting hit in the back all the damn time. Then I became a grown-up. And I realized life changes. And while a kid can take being shoved unexpectedly from behind, grown-ups end up snapping their head, and they may just go, damn it, that hurt. You may hurt them seriously. Because then the more I looked at it, the more I realized, because at the heart of it is it's not about the mangling of metal that causes this kind of an injury. It is the unexpected, awkward, jarring. I'm going to say that again because it's at the core of the revelation that ultimately led to the system I'm going to share with you. It's not about mangling of metal that causes this kind of injury as opposed to a death case. It is the unexpected, awkward, jarring that causes this kind of injury. When I realized that, then it was a matter of applying it to some real life examples that everyone could understand and get. Before I give you those, I want to give you a little preliminary for the lawyers. You need to cover with the jury this topic because there's some people who just made up their mind. If there's not a lot of visible property damage, you ain't hurt. I don't care what the doctor said. I don't care what anyone else says. And there's no strategy will work. They're good people. They're just not good people for this case. They've already made up their mind on an essential issue. They can go down the hall and be in a different case and be great jurors. But there's only one way to find out. You got to ask them. And it's an easy question. You say, how many of you feel if there's not a lot of visible property damage, a person cannot have been hurt seriously, certainly not permanently, no matter what the rest of the evidence says or the doctors say for that matter? You made up your mind. Those people have now, in this honor system, acknowledged this isn't the right case for them. The judge should take them off this case so they can go serve down the hall in another case. So that's an essential part. One more background essential before we get to the way to get the point across to the jury is the language we use. Words matter. Words matter. And this is one of those cases. Don't say low impact. That's their game. Low impact means harmless. Say something more accurate. Not a lot of visible property damage. That's dead accurate, but there's no negative connotation. And in fact, it involves also the underlying concept that there may be more there than meets the eye. Not everyone, lots of people have taken the car and be fixed after a crash, and it looks fine, but it never runs the same. So not a lot of visible property damage, and don't say low impact. So, because there's nothing low about this impact. It may not be high speed, but the impact is powerful. If you ever watch, there are videos out there that show what a 5-mile-an-hour rear end crash looks like on a crash dummy. You would be shocked. They slow it down to slow speed, and it's like, God almighty, 5 miles an hour. Not a mark on the car. And the person gets hit, and first their head goes, and then it goes. And when you watch it in slow motion, you're going, there's nothing harmless about it. But you got to get the point across in simple language. So here was the fruits of the labor of working the wisdom of the wise. There's a little story and then an analogy. And I typically do it in closing arguments when I do this. Let me give them to you. I'll start with the story and I'll roll right into the analogy. The analogy is a little hard on here because I need more room to do it, but we'll get the message across. I don't know why it is that little kids love to sneak up on one another and shove them in the back unexpectedly. But they do, especially those little boys. And I bet you there are little boys out on playgrounds across America right now, sneaking up on their buddy, shoves him, he falls down, he jumps up, brushes himself off, and he squeals and chases him across the playground. They just think it's the funnest game in the world.
Is this an actual analogy you've used in practice, or is this something that you're distilling now for the audience?
No, I tell this to every jury in one of these cases.
Amazing.
This jury, because I'm telling you, when you say it, jurors are nodding because they get it. They're going, that makes sense. But I'm just getting started. Wait till you hear the end of this thing. Because it's not a trick. It's just a really good way to get to the root of the truth that otherwise might be lost. So, chasing him across I don't know why, but right now chasing him across there. You know who isn't sneaking up on one another and shoving them unexpectedly in the back? Grown-ups. Why? Because someone's going to get hurt. Now, I'm going to pause before I roll into the analogy. The moment you say that, grown-ups are thinking, if someone snuck up on me and shoved me, I'd wring their neck. I mean, it sounds hurtful. I hear it and I want to slap someone just thinking about it. When people hear that are grown up, they cringe. And when they cringe, they understand the unfairness of claiming this wouldn't hurt a flea. But you still got to deal with there's not hardly anything on the card or not much impressive. Now we've got the concept that being shoved from behind can be hurtful to grown-ups. It's not a harmless activity. Now let's deal with the external, what the car looks like. So you finish with, you know who doesn't sneak up on one another? Grown-ups. Why? Because someone's going to get hurt. It's like, if someone was sitting in this chair, and I put a chair, and if you're the jury, I set the chair facing this way, so you're looking this way like you were driving, jury's over here. And I sit the chair with nobody in it. It's an empty chair. And I say, if someone was sitting in this chair and had no idea I was coming, and I walk across the room, I give myself plenty of room. And as I'm walking, I'm talking. As I'm walking away from the chair, I'm talking. And I say, now, by all accounts, the speed was somewhere around 5 miles an hour. No one knows for sure, but 5, who knows, 10 miles an hour, somewhere in that range. Now, I don't know what 5 or 10 miles an hour would look like if I was on foot, but I bet I'd be getting it. I'd be running. I'm not going to run like a fool across this courtroom in my dress shoes, suit, and tie. But if I was, I'd be flying across this courtroom. As I'm saying that, I've now turned and I'm walking towards the back of that chair. And I'm coming towards it. I say, but if I was coming at this chair at that speed, and that person had no idea I was coming, and I hit the back of the chair, and I don't make a huge production, but hard enough to make the point. You come up and go, and the chair rocks forward a little. And that person went, ow, what are you doing? That hurt. How fair would it be for me to, and now I turn the chair around so the back of it's facing the jury and point at it. How fair would it be for me to say, what are you talking about? That couldn't hurt a flea. There's not a mark on the chair. It wouldn't be fair at all. Why? Because it's not about the mark on the chair. It's about the unexpected, awkward jarring on an adult's neck that's not supple and is not flexible like little kids' necks are. When you are done, they are done waving them damn pictures around, trying to pretend you ain't hurt. Now, let me add one little other piece to it. Again, this is lawyer talk. Those of you watching this that aren't lawyers, bear with me, but I hope you find it interesting. The defense almost always hires a doctor to come in and say it was just a sprained strain, but not a serious herniation, not a life-altering, forever kind of injury. They rarely come in and say you weren't hurt, because then that means the person's just making up their injury, and they don't want to go that far. That could backfire. So what do they say? Sprained strain, just a little old sprained strain. Well, guess what? Now, in opening statement, you can say this to the jury. They've hired this doctor, paid him a lot of money, handpicked and hired him to come in here and speak for them in this case. They want you to rely on everything he says. We're going to tell you why you ought not rely on him. But guess what even he says? He says that this crash caused an injury to my client. He says it's a little old sprain strain. We'll talk about that. But the point is, even he admits this crash was injury causing to the neck. And the reason I'm telling you that is, I hope now that I've told you what their handpicked witness is going to say and they're going to ask you to believe, in light of that, they're not going to parade around pictures and say that wouldn't hurt a flea because their expert says it hurt the flea. So I presume we're not going to be hearing that during this trial. But if we do, just keep that in mind. Because guess what? They are going to parade them damn pictures around. And now everybody's going to say, what the hell are you parading those pictures around for? Your expert said it hurt them. You're disputing how bad, but you're acting like it wouldn't hurt anyone. This is ridiculous. It's a big fraud. It's a big put-on scam. You kill the scam. And they now look like they're talking out both sides of their mouth. Because they are. You can't have it both ways. Leave the expert home. But don't bring him and say you hurt and say this wouldn't hurt. They're inconsistent. Call it out.
Amazing.
Question,
do you get feedback from juries ever? Like, do you know if certain things that you're doing are more impactful than others?
Sure.
And it's a sort of general question, but I'm just curious.
Sure.
These things are really...
I do two different ways. I have three sources. One, body language. Some people are just stoic. You can't, they could be hating you and you wouldn't know, and they could be loving you and you wouldn't know. Some are that way, but there's usually some jurors when you do these, that, when you do that, they go, you see the little bit of nod. You go, they get it. Some of them I've had jurors who, really liked you. You can see them going, they're like, yeah, go brother. But you get feedback usually from body language, from watching them. I've had believe me, I've had me say stuff, people go, that's not a good feeling. That person didn't like a damn thing I just said. But yeah, you get it that way. You also get it by your verdict. They've been living and dying by the pictures and I get a 7-figure verdict on it. I suspect it worked. Thirdly, sometimes you talk to the jurors and you get feedback. And that's a good place to learn what they like and don't like to teach you going into the future. So that is to any lawyers who know their caseload has a bunch of these, not a lot of visible property damage. I have done this so many times. There is no answer for it from the defense because it's the truth. And all I'm doing is it's a truth that's buried. Your average person would have started out. I bet you anyone watching this who's a non-lawyer was thinking, yeah, if you don't got a dent in your car, don't come in here some big lawsuit. It's bullshit. I hope you go in and go, you know what? It's not that you were wrong. It's no one ever pointed it out to you. And now you know. And now the lawyers know. And I hope I've taken a step in the right direction. And what I really hope as we wrap these segments of these subjects is that those of you that practice what we do, take to heart this process, wisdom of the wise. Apply it. Because I promise you, you can do this on the same kind of case. We've all heard there's a gap in treatment. They didn't treat for a while. I'm not going to run through it because it takes a while. And I'm going to move on to some new topics in our next segment. But I've got a section on that in my book. Deeper Cuts. The person that you represent had a surgery recommended and they didn't have the surgery. Is that a problem? It fits right into this. Same thing. The person you had ends up having a crash later in time after yours. This fits directly into this. The person you represented had a crash before and had some problems before that resolved. This fits right into it. All those classic common things that are just part of the nature of these cases that you're going, oh, I got a bad case. You got a lovable, great case. This applies. So I don't have time to go through it. I urge you, and if you go to, please don't get Deeper Cuts on just any site because they jack the price up. Go to Trial Guides. It's the best price out there. And I'm not trying to sell my book. I want you to buy it. But the amount of money I make, I gobble up in a good steak dinner and a big bottle of expensive wine. So it ain't about money. When I first wrote the book, I would have wanted you to buy it so I wasn't humiliated that no one bought it but my mother. We're past that. It's a bestseller. So why do I ask you to consider it? Because I feel guilty when we finish today that I didn't go through all of them and some more, but I'd be on this subject a month from now. And so I don't have time to cover them all. And then I feel guilty. I'm going to be done. I'm going to go, damn, you should have covered that one. This gives me peace of mind. I can sleep at night because I put it all out there for anyone who's interested, and it's there. It's also, for what it's worth, I have done segments on this in my at-home but not alone brushstrokes. The at-home but not alone brushstrokes are written versions of these kind of gems that work. I've done some on each of these topics I'm talking about. If you want them, they're free. All you got to do is email me at K Mitnik, M-I-T-N-I-K. Don't put a C on it. It's not Nick, N-I-C-K. K Mitnik, M-I-T-N-I-K, at forthepeople.com, F-O-R, thepeople.com. And just say, will you add me to your listserv? And I will, if you don't have these, I'll catch you up on all the past ones. I think I'm up to 43 or 44 of them. And you'll be on the list for all the new ones. And one last thing, please, if you email me, include marnold at forthepeople.com. That's my assistant, Mary Arnold, marnold at forthepeople.com. It just makes it easier. I don't have to then forward everyone to her. She'll get it, and she'll automatically add you. So in any event, thank you. This has been fun, and I look forward to the next one. We're going to move on to some new stuff that I'm really excited about.
Yeah, this was really great. I learned a ton. Like, we talked about how the woman on the sidewalk with that thick bump, maybe she should have noticed it, the defense would say, and then you come in and contextualize it. Well, it's not reasonable when someone's walking. And an older person or someone that's had another accident, you mentioned that to the tank analogy. Well, they would have had more in the tank to absorb it. And then, like today, when we talked about how to connect with a jury and how to be able to just describe things in a way where you're not saying low impact, you're saying accurately what happened. And a bunch of wise nuggets. I don't practice personal injury. I am an attorney, but I feel like I can if I go pick up the book and then just re-listen to these podcasts that we've created. So thank you so much, Keith. This was really, really amazing. I really appreciate your time.
Thank you. I really appreciate it.